Okay, can you hear me? Okay. All right, good evening. At this time, I'd like to call this meeting to order. Good evening, everyone. Today is Thursday, February 9th, 2023, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. All right, can I have Commissioner Kurpis please lead us in the Pledge of Allegiance?
I pledge of allegiance
To
to
the
the
flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you, Commissioner. Thank you, everyone. Good evening, Mrs. Secretary. May we have a roll call, please?
Commissioner Kurpis.
Present.
Commissioner Maggio.
Present.
Commissioner Marks.
Present.
Commissioner Wright. I think she's rejoining, or they're rejoining us.
Yes, President.
Vice Chair Ayers.
Here.
Chair Topson.
Here. Thank you. We have a quorum. Next item is the approval of agenda of tonight's meeting. Commissioners, do we have a motion?
I'll make a motion to approve.
I'll second.
All right, so we have a motion and a second to approve tonight's agenda items. Mrs. Secretary, may we have a roll call vote?
Commissioner Kurpis.
Aye. Aye. Sorry.
Commissioner Maggio.
Aye.
Commissioner Marks.
Aye.
Commissioner Wright.
Aye.
Thank you. Vice Chair Ayers.
Aye.
Chair Topson.
Aye, motion carries and agenda is approved. Thank you, everyone. Our next item is public comments. I'm sorry, approval of minutes. And we have the minutes for the meeting on January 26, 2023. Has everyone had a chance to review the minutes?
Yes, I'll make a motion to approve the minutes of January the 26th, 2023.
Second.
All right, we have a motion and a second to approve the minutes of the meeting on January 26, 2023. Mr. Secretary, may we have a roll call vote?
Commissioner Kurpis.
Aye.
Commissioner Maggio.
Aye.
Commissioner Marks.
Aye.
Commissioner Wright.
Aye.
Vice Chair Ayers.
I'll abstain.
Chair Topson.
Aye, motion carries and minutes are approved. Thank you. Next item is approval, is public comments. Mr. Secretary, can we confirm if we have any speakers tonight outside of the appeal?
It looks like we have Enrique Margulis in the waiting room. His name doesn't, I don't believe he's part of the appeal tonight, so I'll add him in.
Okay, yeah, let's let him in, and maybe we can ask if his statement has to do with the. Good evening, sir. Before I allow you the 3 minutes, I'd like to know if your comments are regarding tonight's appeal, or it's just a
Yeah,
statement.
Mark Pulis in the waiting room. His name doesn't, I don't believe he's part of the appeal tonight. So
Okay. All right. If that's not part of the appeal, sir, you will have 3 minutes. And before we begin, I'd like to acknowledge that the Rent Stabilization Commission values your comments. However, pursuant to the Brown Act, the Commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. And the public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within jurisdiction of the Rent Stabilization Commission. An additional public comment period is available at the end of the meeting. With that said, sir, you have 3 minutes. Please state your name and the city of residence for the record, and you can begin. Can you hear us?
Are you speaking to me?
Yes, sir.
Okay.
Okay,
Hi,
so you have 3 minutes to address the commission, and but before you begin, please state your name and the city of residence for the record.
Okay, I am here on behalf of Derek Ferguson, so he should be on here, and he's going to do the opening.
All right,
statement.
Right, Mr. Mercouli. So that's if your statement is relevant, related to the appeal. This is a public comment segment outside of the appeals. You probably have to wait when we get there. We will allow time for you to speak.
Okay, no problem. In the meantime, I just watch?
Yeah, you can watch this. All right.
Okay, thank you.
All right. Thank you, sir. Thank you. Do we have any other speakers, Mr. Secretary, or not at this time?
not at this time.
All right. Okay, thank you. Commissioners, next would be the manager's report, and we have the Rent Stabilization Manager, Jonathan Hollop. Good evening, Mr. Hollop. So this is your time. We're ready for your report.
Thank you, and good evening, Chair, Vice Chair, Commissioners. Jonathan Hollop, Rent Stabilization Manager. Just going to the look ahead, you have one appeal to hear tonight. Also, there'll be a brief presentation from Eugene Maysky from the Coalition for Economic Survival after the appeal. The next meeting that was scheduled for February 23rd is canceled due to a lack of items. We'll be back in person at Council Chambers on March 9th. And you do have an appeal scheduled for that meeting. The March 23rd meeting doesn't have an appeal scheduled yet, but we may have just gotten one in, so it's possible we'll have one on calendar by the next time we meet. And as I mentioned at the last meeting, the Board of Supervisors extended the COVID-19 tenant protection resolution through March 31st, 2023. Information about the extension can be found at the city's website under Renter Resources, or by visiting the website and making an appointment with an information coordinator, or calling us at 323-848-6450, or emailing us at rsd@weho.org. There's also information on the website stayhousedla.org, and we're happy to answer any questions. So if that's all I have tonight, and if you have any questions for me, I'm happy to answer those too.
All right, commissioners, do you have any questions regarding the manager's report? Okay, Commissioner Corpus, please.
Yeah, I just had a question. Did you happen to get an update? I don't know if you do this at the first meeting or the second meeting of the month, but did you happen to get an update regarding the evictions?
No, I didn't get one. They've been coming in either once a month or once every 2 months. So I probably will have something for you at the next meeting on March 9th.
Thanks.
Other questions? All right, Mr. Manager, I have a question. I believe at the last city council meeting, it was an item regarding the unit swap program in rent stabilized unit. Can you give us a brief kind of an update or overview what was discussed and what was decided?
There was no discussion. The item moved to consent. But the direction to staff is to look into possible incentive programs to encourage landlords to engage in unit swaps where a tenant would benefit from one. For those who may not be familiar with what we're talking about, it's where perhaps you have a disabled tenant on a higher floor who needs to be on the first floor, but due to Costa-Hawkins, as you know, when someone vacates a unit, the landlord can set the rent at whatever they want, and this would staff's been asked to look at ways perhaps that landlords would be willing to do these kinds of swaps in a way that would allow an existing tenant to maintain their current rent. Also directing staff to work on looking to the state legislature to see if there's something that can be achieved that way. So we just got the item, as you mentioned, at the last city council meeting. So we'll be working on that through the next several months and see what we can do.
Okay, would this become before the commission? Because I have at least one or two questions. I just wonder if when I could, address those questions now, or should wait if the item will come before us.
I don't know yet. I think it depends on what staff does, but we can have a discussion about it as it comes closer. If there's input that the commission would like to give, I can certainly agendize something. I mean, I just don't know what form it's going to take, if there's going to be something in the RSO or if it's going to be a program. So I'm not sure what role the commission will play, but certainly we can talk about it if it's an item that the commission consensus is to agendize and talk about.
I remember in the past this commission had a discussion on this matter, and clearly, if this is going to impact the rent stabilized units, so we'd definitely like to hear and maybe provide our input and have a discussion and maybe provide some recommendations that staff could include, and so then present it to the city council, because I myself have a couple of concerns and the questions, and I definitely would like to have this kind of a discussion scheduled sometime before it goes to the city council, if it's possible.
Okay, we can definitely agendize something so that you can give input. I'm not sure when that would be, but as soon as we have something to actually present, we'll bring it to the commission.
That sounds great. And Commissioner Kirpis, I saw that you raised your hand.
You're muted, Commissioner Kirpis.
Thank you. Maybe this is a discussion for an agenda item, but it seems like the city's already done a lot of work on this already. You're not starting from scratch, are you? Are you using reports that have been done in the past on this issue?
There is some information that I have, but I don't have anything. There might be something, but I haven't really been able to do a deep dive yet. That's
okay. Yeah, there definitely is, because there was presentation to the commission in the past. This has been a conversation that's been going on for 10, 15, 20 years.
Right.
Yeah. All right. Okay, thank you. Okay, if there are no more questions for Mr. Pollock, we're gonna move on to the next item number 9, the appeal section of tonight's agenda. And we have one appeal before us this evening, and that is the rent decrease application that is the application D-4697, pertains to the property address 8242 and a half Santa Monica Boulevard And this appeal has to do with the maximum allowable rent determination and overpayments for the subject unit. The appeal is filed by the property owner, the landlord. Before I begin, Mr. Secretary, do we have a representative for the tenant and the landlord?
You do, yes, they're in the room now.
Okay, all right, that's great. Okay, so I'd like to take a moment and introduce the instructions for the appeal process tonight. First, the commission will hear the staff report presented by the legal counsel, Mr. John Natalizio. And as I said, the appellant in this case is the landlord, and the appellant will speak first. You will have 5 minutes to present your case, and you have the option of dividing your 5 minutes into 2 segments. You may use part of your 5 minutes to state your case and part of 5 minutes for the rebuttal. Before you speak, you will identify whether you'd like to divide the 5 minutes or you want to take 5 minutes at once. And the respondent will speak second, and you will have 1 5-minute segment to state your case on the appeal subject. All right. When it is time for you to speak, please state your name and city of residence for the record. The appellant will state how would you like to divide your time, if at all, and you will proceed with your comments. Please make sure that you keep your comments to the topics discussed at the hearing. Any new information or evidence will not be considered or received by the commission. And if you go off topic, you may be interrupted. With that said, Ms. Natalizio, we are ready for your report.
Thank you, Chair, and good evening, Vice Chair and Commissioners. To everyone else, my name is John Natalizio, and I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by the landlord in response to a hearing examiner's decision determining the maximum allowable rent, which I'm going to refer to as the MAR, and overpayments for the subject unit. The hearing examiner found that the unit is subject to the RSO, that the MAR is $1,700, and that tenant has overpaid rent since the initiation of the tenancy. Landlord appealed the decision, stating that it was clearly an error, is not reasonably supported by the findings made or evidence in the record, constitutes an abuse of discretion, and is contrary to the law. I will defer to any sort of legal analysis to the staff report just due to the complexity of this matter. However, as a summary of staff's position, staff finds as follows: that the hearing examiner did not err in determining that the unit is subject to the Rent Stabilization Ordinance, which I'll refer to as the RSO, and the decision is not contrary to the law, and therefore there is substantial evidence in the record supporting the decision on this matter. There is substantial evidence supporting the decision that the base rent is $1,700. However, staff finds that the hearing examiner erred in calculating the MAR without evidence demonstrating what the tenant has paid and currently pays for rent throughout the history of the tenancy. The hearing examiner also erred by calculating the MAR without making a finding as to whether the rent was ever lawfully increased between 2012 and 2022. Staff recommends a remand so that evidence may be submitted by the parties demonstrating tenant's history of rent payments and permitting the parties the opportunity to submit any evidence demonstrating that the rent was lawfully or unlawfully increased between 2012 and 2022, which ultimately resulted in the current rent amount of $1,900. Staff also believes that the hearing examiner erred by not calculating the overpayment. The hearing examiner concluded that there is an overpayment, but did not calculate the actual amount of the overpayment. Additionally, the hearing examiner failed to calculate the total amount of money that must be remitted to the tenant by landlord. Therefore, the decision is not supported by substantial evidence on this matter, and staff recommends a remand so that the hearing examiner can calculate and determine the overpayments, if any. Therefore, staff recommends adopting Resolution RSC 23-622. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard which requires the commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. And the commission does not substitute its judgment for that of the hearing examiner or reweigh evidence. As it relates to questions of law, the commission applies an independent standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you, Mr. Natalizio. Commissioners, do you have any questions regarding the report? I'll start with Commissioner Maggio, and next is Commissioner Marks, please.
Yes, to legal counsel. Of course, we need to determine the maximal allowable rent, but if there's no evidence, how can we do that?
That's a good question. I mean, staff's opinion is that I think the issue is there's an absence of evidence, not that there's no evidence that exists. And so that's why staff's recommending a remand. So that way the parties can submit that evidence for the hearing examiner to consider.
Would that, if we cannot ascertain that information or that evidence, would it not be then more advantageous just to perhaps remand the whole case till we do have that evidence?
Well, I mean, the commission is free to remand whatever portions of the appeal that it wishes. Staff's position is that, as at least as it relates to, you know, the ultimate question of whether the unit is subject to the rent stabilization ordinance, staff finds that doesn't need a remand. Obviously, if the commission disagrees with that, or, you know, believes further information is necessary to make that determination, you know, then a full remand could happen. But as it relates at least to the MAR and overpayments, staff's position is that there should be a remand, so that way there is at least evidence in the record demonstrating payments of the rent throughout the history of the tenancy.
Thank you.
All right. Thank you, Commissioner Marks, please.
Yes, I actually don't have a question. I just want to put something on the record at the start of this appeal. I just want to note for the record that I once had an interaction with Mr. Cohen on a case approximately 8 years ago in a professional capacity. But I want to also note that I can be fair and impartial on this matter, and that we have not had any interactions since that time. So I just wanted to note that for the record tonight.
Thank you, Commissioner, for the disclosure. Other commissioners, any questions at this time? I do have one or two. Mr. Natalizio, the packet includes 3 unit re-registration forms. All 3 have the same dates, but they seem like a separate, not the copy, but the separate documents. They all have, as I said, the same. No, 2 of them, they have the same dates. The third one is dated. Two re-registration forms are dated April 10, 2012. The third one is May 8, 2012. One from April says the rent is $1,900. Another one from April says the rent is $1,700. And the one dated May 8 has the rent $1,900. And we have the admin determination, the department's administrative determination from May 14, 2012, that determines the rent is $1,700. Can you just explain? I'm a little bit confused why there are 3 re-registration forms, all kind of different documents, but have the same dates and the different amounts.
Sure.
Yeah.
Sure. So there's administrative background that I just noted in a footnote in the staff report to provide the context, but isn't a part of this appeal. But the administrative background is that when this unit was re-registered back in 2012, it was initially submitted as $1,700 was the base rent. Then the landlord stated that was actually an error, and then resubmitted another re-registration form for 1900. And ultimately there was some things going on behind the scenes between staff and the landlord and the tenant. And ultimately staff determined an administrative decision that 1700 was the base rent and not the 1900. And that decision was issued in that letter. And that decision was never appealed. And
Okay.
therefore the base rent for the commission to consider is the 1700.
All right. So thank you for clarifying that. I wanted to hear if this decision was ever appealed or disputed somehow, but it seems like it was not. And the tenant's initial payments were for 1700. Is that correct?
So that's part of staff's reasoning for seeking a remand for the MAR and overpayments, because other than the testimony, there isn't any, for example, and 2012 at this point was, over a decade ago. So, there may not be checks showing that, but staff's position is that if the base rent was 1700 and it's now 1900, has it always been 1900? Was it 1700 at one point? Was it 1700 and gradually increased? Was it lawful or unlawful? So we don't have that in the evidence, and that's why staff's recommendation for the MAR and overpayments is a remand to get that information.
Got it. Thank you. And the last question is just kind of a, to have a better understanding. Alienable, separate. Does it mean that the units, if they're, let's say, whether there are two single families on the same parcel, or it's a commercial and the rental residential, do they have to be attached or detached, or it doesn't really matter?
Well, attached and detached, it could. The problem, I think, with tonight's appeal, and I guess I'll just get out ahead here, is that, there could be any number of hypotheticals. I want to be careful to not answer hypotheticals, just because there could really be a case that comes before the commission, and I would prefer to not have a legal opinion on
that's fine. That's fair enough. You don't have to answer it.
But I will say that this analysis under Costa-Hawkins and under the city's RSO is a very fact-intense analysis, in the sense of it's fact-dependent.
Got it. Thank you, sir. Thank you for clarification. I don't have any further questions. Commissioners, I don't see you raising your hands. So with that, we're going to move on to the oral argument portion of the tonight's appeal. But I'm sorry, before that, I know that we have a public speaker, not the tenant himself, but I'd like to provide the members of the public the opportunity to speak on this appeal. As I said, sir, you will have 3 minutes before we begin the oral argument. We'll provide the opportunity for the members of the public to speak regarding the appeal, and you will have 3 minutes to address the commission. And please, before you begin, state your name and the city of residence for the record, and you may use your 3 minutes. Sir, did you hear me?
Mr. Chair, he may need you to say his name so he knows who you're speaking to.
I'm talking about, Mr. Enrique Margulis. That's about you. You requested to speak in the public comment.
Oh, I know. I'm here for Derek Ferguson. I don't have any comments right now, so I'm not.
You represent Mr. Ferguson?
Yes.
Okay. All right. So then we don't have a public speaker at this time, and we're going to move on to the oral argument. And before we begin, for the record, I want to acknowledge that the commission received and reviewed a written statement dated February 2nd, 2023, submitted by the landlord's attorney. And it's on the record. And with that said, I'd like to invite the appellant, who is the landlord in this case, and I believe represented by the landlord's attorney, sir, please, before you begin, you will have 5 minutes. You will let me know if you would like to divide your time between the presentation and the rebuttal of your statement today. Before you begin, state your name and the city of residence for the record, and you may start.
Thank you. My name is Mark Cohen. I live in Los Angeles, California. And just to go off of Commissioner Martz's disclosure, I have been before this board before where Commissioner Martz has been on it. And that was post the case we had together. And we've only interacted in a professional capacity. Otherwise,
thank you. Appreciate the disclosure.
Yeah. Otherwise, I will take 1 minute for opening, the remainder for rebuttal. And just let me know when you're ready for me to begin.
You may begin, and then Mr. Secretary, you noted that 1 minute now and 4 minutes later.
Yes.
Thank you, sir. You may start now.
Thank you. So this is actually a really interesting case dealing with the Costa-Hawkins. The evidence is undisputed, and there was a finding by the hearing examiner that there is one dwelling unit and one commercial unit. There's the Costa-Hawkins Act states that the rent control cannot apply if there is only one dwelling unit on the property. It needs to be separate and alienable and all of those things, which it is separate and alienable from any other dwelling unit. It doesn't matter if there is a commercial unit and a dwelling unit. I think I laid it out pretty well in my brief. It's the alienability doesn't matter. Every other rent control jurisdiction only applies when there are two or more dwelling units on the property. The case that the city attorney cites dealt with a single family house that was being used as multiple dwelling units. That's not the
That's 1 minute.
Thank you, sir. All right, so you have the remaining 4 minutes you can use during your rebuttal. Let me ask the commissioners if you have any questions to Mr. Cohen this time. All right, I've seen no questions. With that, I'm gonna invite the respondent, the tenant in this case, and Mr. Ferguson, you will have 5 minutes to present your case, to state your case, and again, please begin with stating your name and the city of residence, sir.
My name is Derek Ferguson. I live in West Hollywood, California, and I'm a tenant.
Thank you. You may begin your presentation.
I will be taking 1 minute and then leaving the other 4 for after.
Please? I'm sorry, but for the respondent, you have to take the entire 5 minute segment at once.
Okay. Okay, well, my lease was written at $1,900 a month, March 15th, 2012. I paid the $1,900 on time every single month since day one. I've never received a notice, formal or otherwise, indicating that there was an issue with the rent not being paid or being late. I kept it scheduled. It was consistent to date. I'm still currently up on my rent, and it's current as we speak. And the estoppel certificate on file reflects this fact. Thank you.
That concludes your statement tonight?
Mm-hmm. Yes.
Okay. All right. Thank you. Commissioners, Commissioner Kerpis, please.
Yes, thank you, Mr. Ferguson. So your initial amount paid in the unit was $1,900, not $1,700?
Yes. The first time I paid rent was $1,900, and it has been ever since.
Okay. Thank you.
Other questions? I have a question, Mr. Ferguson. Back in 2012, did you receive this admin decision? This letter dated May 14, 2012 from the department?
I don't have that record on file. I believe I received it. We're talking 11 years ago now.
Okay.
So I could be.
So you don't recall paying or questioning why the letter indicated $1,700?
Well, I was told 1900 from the beginning. It's written in the lease, and so that's why I have always paid it.
Okay, all right.
Yeah.
I just wanted to check on that. All right,
Yeah,
thank
yeah.
you, sir. If we don't have any questions, Commissioner, so I'm gonna invite Mr. Cohen back. So then we can hear the remaining 4-minute statement. Sir, Mr. Cohen?
Thank you.
Yeah, this is your time.
Thank you. So Mr. Ferguson made a point that there was an estoppel certificate for $1,900. This is a relatively new owner of the building. Under Plaza Freeway Partners versus Baja Fresh, he would be stopped from claiming any other rent otherwise. But more importantly is the issue regarding the RSO. Civil Code Section 1954.52A3A provides that notwithstanding any other provisional law, an owner of residential real property may establish the initial and all subsequent rental rates for a dwelling about which the following is true. Subsection 3A, it is alienable, separate from title to any other dwelling unit. There's actually a discrepancy in the WeHo Municipal Code. It does not say separate and alienable from any other dwelling unit. It would be preempted by the Costa-Hawkins Act. And it's an issue that, if this commission finds that I'm incorrect about the law, it will seek further judicial review because I believe the law is very clear. Although I appreciate the staff report's analysis, I think it's wrong because the question to ask is the residential dwelling unit separate and alienable from any other dwelling unit? The facts are undisputed that there is only one dwelling unit, one residential tenant that lives at this property, and a commercial tenant that does not live at the property, that is the Love Connection store on Santa Monica Boulevard. Does anyone have any questions for me?
When you conclude your statement, if the commissioners will have questions, we'll ask you, sir.
I'm concluded.
All right, thank you. With that, commissioners, do you have any questions to Mr. Cohen? All right, I don't see any questions, sir. With that, I will close the oral argument portion of the appeal. And we will begin the deliberation. But before we do that, let me see if the commissioners have any questions for the legal counsel. Okay, Commissioner Kirpis, and then I think Commissioner Wright, you also have a question? Or no? Okay, Commissioner Kirpis.
Yes, I have a question from you, Mr. Natalizio.
Yes, please. Mm-hmm.
Waiting for him to come back on. All right. So the tenant just testified that they've always paid $1,900. That was in their lease. They've always paid it. Why is the city's documents relevant at all in this case? If what sets the base rent is the rent and what's actually charged.
Well, I mean, if you're looking at the definition, the RSO of base rent, right? It's the initial rent demanded, charge collected. But in this case, because the city has previously determined that the MAR is $1,700, it doesn't matter then what was actually demanded of the landlord if it's in excess of that, because landlords aren't allowed to collect rent that's in excess of that. And the administrative background for this case for why it's $1,700 was because city staff found that there was conduct on behalf of landlord which resulted in an involuntary vacancy. And under the RSO, if you have an involuntary vacancy, you cannot raise the rent above what the previous vacancy, what the previous rental rate was. And so the previous rental rate was $1,700. And so because city staff found that there was tenant harassment, that's why the MAR was $1,700. And that was the administrative decision that was issued and never appealed.
So that would create an exception to the rule of first initiated rent, and what you paid, right? Because it's to protect the tenants, or to prevent people from treating the previous tenants the way they did. So they're penalized by making the rent go back to what it was when they left, right?
Correct. It's to avoid a landlord from engaging in unlawful acts to get somebody out just so they can raise the rent.
Okay. Thank you.
All right, thank you. Other commissioners? Nothing at this time. I don't see any questions. So now we're gonna move on to the deliberation by the commission. Who would like to begin? Commissioner Martz, maybe?
Sure, happy to.
Thank you.
All righty. So I appreciate both parties' comments here, and I appreciate Mr. Cohen's comments that this is, I don't know if you said this, but I think it was implied that this is a little bit of a tricky question here. There's not a lot of case law on this issue, but I am going to agree with the staff report's recommendation, and I go down to that. We have to look at the law separately from what the hearing examiner decided. That's the requirement here. And looking at the case that is cited, City of Oakland Housing versus Lauren Bargo, which I think both parties have discussed, or the staff report does. What it comes down to for me is a section on page 6, and it's a little bit technical, but the homeowner in that case who lost, who wanted his single family home to be exempt from Costa-Hawkins and rent control, the court summarizes arguments as long as the structure is a single family residence, and here's the key part to my understanding and thinking, and it is alienable apart from any other structure because it has its own title and can be sold separately, then it is not subject to local rent control. And that reading to me implies not just another dwelling unit, but we need to look at the property as a whole. And does it have its own title, and can it be sold separately? And here the answer is no. The rental unit from the commercial unit. So I do think that the West Hollywood municipal code applies to this, and that this property is not exempt from Costa-Hawkins at the state level. And so I do think the staff's interpretation is correct, and I would agree with their draft resolution that's in the file.
Thank you, Commissioner. Commissioner Kirkus?
Sure. I will. I'm not a lawyer. I think that both sides made pretty compelling arguments and supported those arguments. But considering that I rely heavily on our staff, and I'm not inclined to reduce the number of units covered by rent control, I'm going to side with staff on this. And I know that it'll go on to the courts, and the courts will ultimately decide for you, and then we will all have an answer. But for now, I'm gonna follow staff's recommendation, and then I agree with all the other recommendations for remand. We don't have the evidence to show whether the rent was raised legally or illegally over the years. Sounds like you guys are gonna have fun in the hearing examiner's hearing, explaining why we're having this discussion, first of all. But yeah, so I agree with staff's recommendation.
Thank you. Commissioner Wright, please.
Thanks. So I think sort of just off the top, the West Hollywood definition of dwelling unit is more restrictive than the state unit, which gave me a bit of a struggle with whether or not, this unit does indeed fall within it. I think the sort of outside research and looking at similar cases and things like that didn't turn up enough sort of case law on point, and even some of the treaties said it's unclear. And I think based on that, and based on the Oakland case, I am inclined to find that the unit does fall within the West Hollywood rent stabilization ordinance. I would also be in favor, if there is some sort of mixed opinion on it, of remanding the entire case. And if it's, I don't know if this is a thing that we can do, but if we're permitted to send over some of the case law and treaties that we found for review or re-review by the hearing officer as they're reviewing the other issues, to also relook at the definitions in West Hollywood's code and the state code of dwelling unit, et cetera. I would be open to that. And if that's not on the table, then I am inclined to go along with the staff's opinion to remand certain portions and not remand the other portion. Thanks.
Thank you, Commissioner. Commissioner Maggio?
Yes. I'm in agreement with the staff that the hearing examiner's decision determining the unit is subject to the rent stabilization ordinance, which should be affirmed. The hearing examiner's decision determining that base rent is $1,700 should be affirmed. The hearing examiner's decision determining and calculating the maximal allowable rent should be remanded. And in regard to the hearing examiner's decision of determining any overpayment, that certainly has to be remanded. I am curious about the law in regard to one title for the property. Both the living quarters and the commercial are definitely both, in a sense, under one roof. And I think that has to be looked at more clearly. I would be in agreement to agree with these first issues that I have mentioned. However, we have to determine whether the landlord improperly increased the rent from $1,700 to $1,900. And I think that part, of course, would have to be remanded. Although I would not mind looking at this case differently where it is entirely remanded until we can really determine some of these other issues that I think are so pertinent to the case. That's all I have.
Thank you, Commissioner Maggio. Vice Chair, please.
Yes. I think that since the hearing examiner did decide that the unit was subject to the RSO, and we're pretty much in agreement with staff that that is the case, I don't think we need to remand that part of the decision. But I do agree with my fellow commissioners that we should remand the part of his decision regarding the base rent and determining, going through more evidence collection regarding what the MAR should be. And that's it.
Thank you, Vice Chair. Just very briefly is that I find the landlord's argument and the statement compelling, but going back and forth, I would agree with the staff's analysis, where the staff says that the property consists of a single dwelling, which consists of a commercial front and the residential unit, and that because the commercial is not separately alienable, so cannot be sold or transferred separately from the rest of the property. So by de facto, the residential unit is not exempt under Costa-Hawkins. So because that would be incorrect application of the law. That's in my opinion. So I would agree, although as I said, that the landlord's the attorney's argument is very compelling, but I'm leaning towards the staff's recommendation, and I agree with staff's analysis regarding the our sole determination for the subject unit, and in regards the determination of the base rent, the MAR definitely has to be remanded because we want to open the record and see what documents would be submitted, because we've heard the statement from the tenant tonight, and we have some documents that show different rent amounts, and we have the city's admin decision from 2012. So we definitely want to open the record and see what documents would be submitted, if any. And if the rent would determine 1,700, and if there will be any overpayments that would be due to the tenant, so that's definitely should be also remanded. In other words, I agree with the recommendation to affirm in part and remand in part the findings of the hearing examiner in this matter. With that said, commissioners, anyone would like to entertain a motion?
Okay, I'm here. Can you hear me?
Yes, Commissioner Maggio, yes.
So I am going to recommend that the commission adopt resolution RSC 23-622, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and remanding in part the hearing examiner's decision as to rent decrease for application number D4697, and I will mention the address as well, which is 8242 in 1/2 Santa Monica Boulevard.
I will
All right,
second
thank
that.
you, Commissioner. All right, thank you. We have a motion to affirm the to adopt the resolution as it presented, and we have a second. Further discussion on the motion? I've seen none. Mr. Secretary, may we have a roll call vote?
Commissioner Kirby?
Aye.
Commissioner Maggio?
Aye.
Commissioner Marks?
Aye.
Commissioner Wright?
Aye.
Vice Chair Ayers?
Aye.
Chair Topshin?
Aye. Motion carries. Thank you, everyone. Thank you, both parties, for your statements tonight. And if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 or by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. If you have any questions about the appeal tonight.
Would you repeat that phone number, please?
Sure. It's 323-848-6450.
Thank you.
All right. You're welcome. For the parties who attended by Zoom, who join us through Zoom this evening, you will now be placed back in the waiting room. If you'd like to watch the rest of the meeting, you may find your options to do so at weho.org/WehoTV.
Thank you very much for your time. I had a quick question for Mr. Natalizio.
That would be probably the proper way to contact him outside of tonight's meeting, sir. But I'm sorry about that.
Appreciate all of your.
Thank you. I appreciate your testimonies. Thank you.
Thank you.
With that, I would take a 5-minute recess, and we'll be back at 8 p.m. to continue with our meeting tonight. right, it's 8 p.m. and the commission reconvened. So we're going to move on to the next item on our tonight's agenda, which is item number 10, new business. And we have the presentation from the Coalition for Economic Survival. And this is a recommendation from the staff to receive and file. Staff would like to make any mention anything before we invite the presenter?
I just want to thank Eugene for coming tonight, and I leave it to him to give the presentation. Thanks, Eugene.
Okay.
Thank you
All
so
right,
much.
thank you, Ms. Manager. So we have Eugene Maysky here, whom I know personally. He is also, besides working for the CES, he also is the chair of the Russian Advisory Board. Eugene,
Now just a member. We had our elections recently.
Oh, okay. All right. A member, board member, and also the representative from the Coalition for Economic Survival. Eugene, welcome back to the commission. You've been here before, and we're glad to see you. And we would like to hear what you have for us tonight.
Thank you.
This
I
is your
really
time.
appreciate it. Good evening, Chair Dobchin, Vice Chair Iris, commissioners, CC staff members. For everybody else who I haven't met, I'm Eugene Maysky. I'm a tenant outreach organizer for Coalition for Economic Survival. We are a 50-year-old multiracial, multicultural, grassroots community-based nonprofit organization assisting, organizing, and empowering low and moderate income renters in West Hollywood, Los Angeles, and all over Southern California. I would like to thank you for welcoming me into your meeting and allowing me to provide you with this update on the issues that we are facing and working at CES on a daily basis. CES actually helped create the city of West Hollywood and led the effort to win rent control laws in West Hollywood, in our city, and in Los Angeles, and most of the local laws that protect tenants to this day. And we achieved all of that with the help of the tenants, participation of tenants. That's why we always encourage tenants in West Hollywood to become CES members and join 6,000 plus tenants all over Southern California to make sure that we all stand up for each other and make sure that everybody knows that power is in numbers. As in previous 49 years, our focus, as always, is on protecting rent control, combating slum housing conditions, stopping unjust evictions and displacement of tenants, protecting neighborhoods against gentrification, preserving government-assisted low-cost housing, eradicating housing dangers, for example, exposure to lead paint poisoning, and advocating for new affordable housing through political and legislative initiatives. I appreciate this chance to address Commission to bring attention to some of the most critical issues we've been battling in our community recently, including growing attempts of unlawful evictions and a lot of cases of tenant harassment. That includes cases where long-term rent-stabilized tenants are being pushed out of their RSO tenancy by all means necessary. We're talking about low-income, disabled, elderly tenants and tenants being discriminated because of their age, gender, disability, race, sexual orientation, national origin, health conditions, or other situations. In the past year, we've had cases where several landlords went so far as filing frivolous lawsuits in civil court, not one or even several, as one of the scare tactics to force tenants out. And of course, they still deploy all the oldies but goodies: intimidation, denial or delay of repairs and maintenance, cash for keys, harassment, decrease of services, and many other not so obvious tricks, but they still work, unfortunately. Recently, during our weekly clinics that we have, we've noticed several alarming growing new trends that I need to report on. So the first would be gouging prices on single-family dwellings. Currently, we have 3 cases. One is where one of the tenants is, his price is being gouged for $2,000 in one paying cycle. The other is a 90-year-old tenant in West Hollywood who is an elderly lady whose rent has been hiked for $900. And there's another case where the tenant is approximately facing hike of the rent around $800. The second trend, concerning trend is growing, is Airbnb situations, where landlords are blatantly disregarding our city laws and prefer just to pay citations and continuing almost openly conduct their short-time rental business. We currently dealing with one of the cases like that, where it's just blatantly disregard to all of our ordinances and laws. Third trend is something that we've been seeing all over 2022, and it continues, unfortunately, this year. Landlords are separating the rent fee and the parking fee, and then hiking up the parking fee, or taking the parking away as a pushing RSO tenants out, scare tactic. So this is something we've been seeing a lot all of last year, and it continues now, unfortunately. The fourth trend and the fourth situation we've been seeing recently is during the recent clinics, we've noticed that tenants don't have enough information on how state rent control 1482 pertains to their tenancy. So we would like to work with the city to provide more information on 1482 state rent control and explore perhaps if it needs additional resources to implement this research. We can also research how other cities in California are dealing with 1482 implementation and enforcing, which would be also a very important part of it. And the fifth is probably the most egregious. We come to this part that is the most hurtful to all the tenants, is the tenant harassment. Our city has the strongest tenant harassment ordinance in the country, I believe. And thanks to our rent stabilization division and city council, who really worked and fought to put it in place to protect our tenants, we have that rent tenant harassment ordinance. And now we're working on the mechanisms how to enforce that, because that second part of enforcing that tenant harassment ordinance is very important on a different level, actually. Right now, we require tenants to provide evidence on the level of criminal harassment, almost like in court, to even take on their case. So sometimes some of them don't need that level, and it would be great if we could just have a letter of compliance from the city to tell the landlord to stop harassing the tenants and leave them alone and respect their rights. In some cases, cease and desist letter would be enough to help the tenant situation. This is something that we need to explore together as one of the instruments when we're dealing with tenant harassment, especially repeat offenders. For example, one of the most egregious cases we have is with LLFO Properties, who's been involved in multiple cases with multiple properties in West Hollywood and multiple hearings. For the past 2 years plus, they've been aggressively harassing one of the tenants. I'm not going to name a name of the tenant, but aggressively harassing a disabled, low-income LGBT tenant surviving with AIDS, and they went as far as hiring 4 law firms to attack him and in civil court to get him out of his RSO studio apartment. This is an ongoing case, and this is just one of the examples how far sometimes landlords would go in order to get rid of our RSO tenants we need to protect. What are we doing to actually protect them? We have 2 tenants' rights clinic every Wednesday at 6 p.m. and every Saturday at 10 a.m. We have renters can receive free consultation. They can just register, come to the clinic via Zoom from the comfort of their home, and talk to the best tenants' rights attorneys via Zoom or phone. We're conscious of the digital divide, so we're working on making it as accessible as possible for every resident in our city. And we also provide support to monolingual communities, so we work in 5 languages, including Russian and Spanish. Also, every month, in partnership with the City of West Hollywood, we provide educational Know Your Rights forum via Zoom, where representatives from the City Rent Stabilization Division and CES talk about the most important issues, current issues, and then we answer tenants' questions. Our next forum is on Monday, February 27 at 6 p.m., so please join us. We'll be happy to have you. We're also working closely with other nonprofits, including National Council of Jewish Women, to assist tenants. We work with programs like Homeless Prevention Assistance Program and EDP ERAP HIC program to help tenants with back rent to keep their tenancy. In addition, we do meetings at buildings assisting renters who want to form tenants associations to ensure their rights are upheld. And given these laws are changing and there is a lot of confusion, it is crucial that renters know their rights. So we've been working with a network of volunteers placing flyers for our clinics all over West Hollywood. And that work will also very successful part of our outreach. We do outreach online, but now we do it in person with the flyers too. If you know anybody who needs our help, please send them to my direct phone line, 213-252-4411, extension 205, 213-252-4411, extension 205, or to our email, helpingviхорenters@gmail.com, helpingviхорenters@gmail.com. Thank you so much for this opportunity to report to you, and I really appreciate it. And if you have any questions for me, I would be absolutely happy to answer those questions.
Thank you, Eugene. I see Commissioner Maggio has a question.
Eugene, are you there?
Yes, absolutely.
How are you tonight? Thank you for coming before us. You're always informative, and you do articulate the issues well, and we're certainly grateful. My question to you is in regard to the elderly individual who is being or trying to be evicted, who is living with AIDS. Do we know who is helping this individual with their legal fees? Is CES helping in that way, or helping to obtain attorneys to represent him? Can you give me any information on that?
Yes, I'm not allowed to disclose the name of the person, but in general, I can speak about the case.
Yes, of course.
As of right now, last year, we've been able to work with Beth Sadik, who's under the contract with the city, and they had together we worked on the referral. So because it's a civil court, it's really hard to actually find any free attorney help and attorney assistance. But still, we've been able to help to find help for him from Latham and Watkins, because at this point, the amount of attorneys put together by the LLFO properties, it's 4 different firms that they've hired. And honestly, just between us and everybody who watches us on WehoTV, it's a very weird situation when a billionaire family is going after one tenant in one rent-stabilized studio apartment. And they are literally a billionaire family. So this is a very concerning situation that we've been fighting, and we've been fighting for this tenant more than 2 years now. So, and they've been harassing him in all kinds of ways, installing uninsulated washers and dryers right, left, and up and on the side of his apartment. And because he's deeply traumatized, he can't withstand the noise that's coming out of all that. So it's a very tough case. Every one of us nonprofit workers have that horrible tough case. This is one of the cases where you feel the situation with all of you being, you know. We're working on this case like all the time.
Thank you very much.
Absolutely.
Thank you. Other commissioners, are there any questions? Comments? Commissioner Corpus, please.
Eugene, thank you for the presentation. That was very good, very informative. You mentioned AB 1482, and that's the 10% statewide, or limits the statewide annual increases to CPI plus 5, I think, or something like that, but maximum of 10% under any circumstance. Are you asking that the city be more involved in helping to educate and enforce, or at least hold landlords accountable to those rules? Is that what you're asking for? Is the city to be more involved in that way?
I would very much like to work together on informing the tenants about that, informing them about that right. And we do that in the clinic. Whatever tenants come to us and they are not under West Hollywood rent stabilization, but they are under state rent control, our attorneys inform them and give them the whole situation. They explain to them how it works.
This was the televised meeting.
They explain to them how it works, but we probably should enforce it, but look into enforcing it a little bit better. Yes, that would be a great kind of like, we need to explore how to enforce it a little bit better.
Thank you.
Thank you.
Thank you. Commissioner Wright, I think I saw you raising your hand, or was it? Oh, all right, okay. Yeah. Other commissioners? All right, Eugene, thank you. It was very informative, as before. And I have one question. I'm not sure if Commissioner Maggio asked this question about the same tenant or is a different tenant. I heard you in your presentation mention the rent gouging cases that that CES is working on, helping the tenants. And you specifically mentioned one case where the senior citizens rent has been hiked by $900 or something like that, without disclosing anybody's name, obviously. Is this a rent stabilized unit you're talking about, the particular case?
Unfortunately, this tenant is not under rent stabilization, but we're working with her to make sure that we provide her with all the information and potentially press coverage or something like that. We also looking into important issues. She is just turning 90. She is also one of the greatest modern movie composers of our time, and treating our residents in this way is completely dreadful and disgusting, I believe. This is not the way we should treat people who actually served our community and created things for our community for the longest time, especially elderly tenants who don't deserve that treatment in any way. So we need to do better for our elderly members of the community, for sure. So the work is ahead of us. We need to do something.
Thank you, Eugene. Yeah, my concern was if it's a rent stabilized unit or it's a unit subject to AB 1482 state law, state regulations. So obviously your lawyers, they know what they're doing, and your agency as well. I was just concerned if maybe something that the department should get involved in. But nevertheless, very informative, as I said, interesting. And I see there's a lot of work you personally do on behalf of your agency in the city, and thank you for that. And obviously the tenants in our wonderful city of West Hollywood, they should know that they have rights, whether tenants are under rights under the rent stabilization ordinance or rights under the state tenant protections rules and regulations. So there are rights out there, and obviously the tenants should contact the department and or the Coalition for Economic Survival if they have any questions. And this is wonderful that your agency continues to hold this weekly legal work tenants' rights workshops. And I didn't know, but unfortunately, well, actually, I've seen those advertisements about the forum, the tenants' rights forum. I didn't know though it's once a month, but it's good to know that you also have the forum every month. So I'll try to attend, and maybe we'll have a couple of questions also. So, anyways, thank you very much. It was
Thank you so
really
much. We always
pleasure.
appreciate your support, because your support and support of our rent stabilization division of the city, who we work with on a daily basis, is very important to us. So thank you. I appreciate you very much.
Thank you, Eugene. Thank you very much. Good job. And we'll see you again sometime in the future. All right.
Absolutely.
Good luck.
Thank you so much.
And good night. Thank you. That concluded the presentation from the Coalition for Economic Survival. And it's basically a recommendation to receive and file. So the next item, which is item number 11 on the agenda, is the items from staff. Mr. Manager, we want to have you back. All right, you are back.
I'm back.
Anything from you in addition to what we've discussed tonight?
Nothing further from staff. Thank you, Chair.
All right, thank you. Questions, commissioners? All right. So if we don't have any questions, we'll move on to the next, which is the public comment. I wonder if we have any speakers at this time, Mr. Secretary.
We have no speakers at this time.
No speakers. I knew that. All right. Items from the commissioners. Anything, Commissioner Kirpis?
Yeah, just to follow up on that, the conversation we were just having, or the presentation we were just having, I wanted to see if we could add to a future agenda presentation on those aspects of the law that fall outside of the RSO, but are clearly housing issues, and how, if we get a presentation from staff on how they handle those sorts of questions, and what the city's limitations are on getting involved, because ideally, I'd like to see a presentation that maybe turns into a recommendation to the city council that the rent stabilization department and housing department takes on a more formal, I know they already do a lot of this stuff, but a more formal assignment to deal with like issues like enforcement of 1482.
Well, to respond to that, we're limited in what we can do there. So I can present something about 1482. Be happy to do that. And as we've discussed previously, the city is rolling out a full registration program for both rent stabilized and non-rent stabilized units, which will include the designation for those properties that are covered under AB 1482. So that kind of information will be easily accessible to staff. But, local control has not been granted yet, and I'm not sure it will. But I can discuss AB 1482 and in a future meeting and get into those specifics.
Yeah, and even, I mean, not just 1482, but 1482 is the obvious one. But even situations where there's a lot of times that there are, the remedy is a civil remedy that sometimes the city gets involved in and sometimes it does not, unless the tenant do it on their own. And I just want to kind of better understand how those decisions are made. And I know it's a fine line you have to walk, and you can't be an attorney for every person and file their grievances. And I think the city's been doing a good job at how they do it. I just want to understand how they make those decisions.
Okay, I can present something on that in a future meeting.
Thank you. If my colleagues agree, I mean, if majority of them agree.
I would agree. Yeah, it's a good idea. Thank you.
Fine by me.
Commissioner Mache.
Yes, for Jonathan, I had one question. Have you put together any dates for perhaps a upcoming study session, a major study session, not a mini, for the commission?
Not yet. I know we might have some change in the commission, and I anticipate doing something once we have a full commission.
Thank you.
Thank you, Commissioner Mache. Thank you, Mr. Manager. Other comments from commissioners? All right, I don't have any comments at this time. So no more comments, and that's with this, we're gonna adjourn our meeting until the next regular meeting of the Rent Stabilization Commission to be held on March 9, 2023 at 7 p.m. And that's going to be in person in West Hollywood Park Public Meeting Room, Council Chambers. So thank you, everyone, and good night. And I'll see you, commissioners and staff, next time in person. Thank you and good night.
Good night.
Good night.
Bye-bye.
Good night, everyone.